Hi, my name is Nick Mermiges. I'm a divorce and family attorney in South Carolina. My main office is here in downtown Columbia, South Carolina, but I do take cases statewide and certainly all around Columbia. And today I'm just going to talk about a few of the issues that pop up in military divorce and that are kind of unique to military divorce. Our firm handles quite a large number of military divorce cases, and that's because Fort Jackson is basically right next door. It's right in town. And then Shaw Air Force Base is in Sumter, which is also quite close. So, we handle plenty of cases with active duty military, retired military, and there's also quite a large number of guard or civilian contractors, things like that, okay? There are a few specific issues that make military cases unique relative to other normal divorce cases. The first thing that we always get questions about is how military retirement is divided. Okay, sometimes people call and they think that if they haven't been married for 10 years, 10 service years, okay, so 10 years during the marriage that were also active duty military service, think if they don't have 10 years they can't get any portion of the service member's retirement, or the service member thinks they don't have to pay anything because they haven't been married for 10 years. That's not true, okay? A military retirement is like any other retirement. It'd be like an IRA. The portion that was accrued during the marriage is marital property, and it's divisible. The family court can award the fair share of whatever the marital portion of that retirement is. The 10-year requirement is the 10-10 rule. Okay, and that is not a South Carolina family court requirement. That's actually a requirement that the military itself has, DFAS, the Defense Finance Accounting Service. They won't pay the spouse's share of that retirement directly to that spouse unless there's 10 service years in the marriage. Okay, so basically, if there's 8 service years, that doesn't mean that you can't get any. It means that DFAS won't pay you your share directly. Okay, instead, the court can just order your ex-spouse to pay let's say every month that check comes in, it can order your ex-spouse to just pay you your share of it every month, okay, so long as that retirement continues. So for example, let's say you've been married 8 years and someone, retires at 20 years, okay, basically you've been married to that person for 40% of their military service, right? 8/20, 4/10, 40%. So 40% of the time that they accrued that retirement, y'all were married, okay? You're entitled to half of that. You're entitled to half of what was accrued during your marriage. So half of 40% is 20%. Okay, so you get half of, what was accrued during the marriage. So as I said, on an 8-year marriage, that's 40% of the service. You're entitled to half of what was accrued, which means 20%. So that would mean you'd be entitled to 20% of the person's retirement. Okay, and even though DFAS, doesn't pay it to you directly, you can get it. The court would order, your ex to pay you your share every month, and the court is completely within its powers to do that. And obviously, 20%. Of a $2,500 a month retirement, for example, that's $500 a month for 10, 20, 30 years, as long as the service member is living, okay? If you do have 10 service years, DFAS will pay you that directly, okay? I mean, you don't even have to bother with communicating with them to try to get the check. And just to be clear, there are things that you can do, like set up allotment, so you don't have to be contacting the person every month, okay? But what matters is having an attorney who knows how to, 1, look for things, 2, determine the fair fractional share of the retirement, 3, if it's a 10-plus service year marriage, write the order in a way that DFAS will honor it and pay you directly. 4, if it's less than 10 years, write the final order in a way that it's clearly enforceable, okay? So that if someone tries to stop paying it, you can bring them into court, you can get your remedy, and they can be duly punished, okay, if it comes to that. So that's how retirements are handled. And obviously, if it's a guard retirement as opposed to an active duty military retirement, guard retirements are based on points that are accrued. The spouse is entitled basically to half the points that were accrued during the marriage. That's their percentage of the person's retirement. Okay, so instead of it just being service years, it's based on points, because folks in the guard, they'll get more or less points during a given year depending on their assignments and if they're on active duty and things like that. Okay, but the same principles apply. And the point is you need to have an attorney who looks out and is able to obtain those documents. Okay, as far as the financial side of things, the military retirement part is really the biggest distinct detail that you run into in family court cases. Military disability is not divisible. Okay, a court can't award half of your disability check to an ex-spouse. Okay, they can't divide it. They can consider that income for purposes of alimony and child support. Okay, which means that it'll be considered your income, but they can't just order it to be split in half and paid directly to the ex-spouse or have the marital portion split. There is a very small kind of exception to that, but several years ago they changed the law. They made it a lot easier to get a full disability payment on top of a full retirement payment, but there are some circumstances where if you waive a claim for retirement in order to get disability, that potentially could be divided, at least to the amount of retirement that you waived to get the disability. Okay, but that's a very rare exception in a highly specialized area. Generally speaking, disability is not going to be divided. But again, it is going to be considered income for the purposes of child support and alimony, because there are plenty of folks who get a retirement, get a disability, and then they wind up taking a job, whether it's a civilian job with the DOD or they start their own business or whatever else. And so, especially in a long marriage, if people have been married a long time, that's going to be considered income by the court when they're considering and calculating alimony. Okay. The other issues that frequently pop up in military cases mostly have to do with custody. Obviously, military folks frequently rotate around the country. They PCS, permanent change of station. Sometimes they are sent overseas. Like Ramstein base in Germany, or I've had folks stationed in Italy, and they don't always take their kids with them, okay? Or the parent, the mother, for example, will stay back stateside with the kids while the father in this circumstance would be deployed abroad, okay? Normally, if you're in the same city as your kids, at the very least you would get sort of what's considered standard visitation, which is like every other weekend, usually dinner once a week, half of the holidays, every other Thanksgiving, a week at Christmas, every other spring break, and you'd usually get about 3 weeks in the summer, along with some other small holidays. And that's really the minimum that most fit parents get, as long as that's what they want. Okay, and a lot of fit parents get a lot more than that if they hire a competent attorney to deal with their custody issue. Okay, but if you're overseas, you obviously can't do every other weekend, right? And so under those circumstances, you can have an attorney. Basically, you can change your visitation schedule in a way that allows you to have more blocks of time with your kids. So you can, for example, you can potentially, sometimes it's a fight, sometimes it's not, but you can potentially get six consecutive weeks in the summer, right? Or, up to 6 weeks based on how much leave you get. And you have to tell the other parent, when your leave is, how much leave it's going to be, and then you'll have that whole block of time. You can potentially get every spring break instead of every other spring break to make up for the fact that you're not able to be there every other weekend. You can also get, specific requirements about making sure the kids are available to talk to you on Skype or, phone or any kind of video chat. You can get a specific amount of contact so you can maintain that relationship with your kids. But the point is that, when you're a service member that's deploys or is deployed, you can get accommodations from the court that give you more time to account for the fact that that's what you're doing, okay? And then beyond that, if you have an attorney who has sort of who wants to avoid you having to come back into court, your order can potentially contain provisions that basically say, if when you come back, you're living within 30 or 40 miles of your kids, your visitation schedule will automatically change, meaning you'll get, at least every other weekend, dinner midweek, things like that. And, sometimes folks can work that out on their own. And it's great if they do, okay? But what's important is to have sort of a guaranteed, enforceable minimum so that you don't have to hire a lawyer again once you come back stateside to modify your custody agreement just so that you can see your kids, okay? So that's another big issue. And on top of that, once kids reach a certain age, if you're deployed abroad, you may want to have them come visit you. It's great for kids to travel abroad and visit their family members. And if that happens and you have an uncooperative spouse, I frequently see people, sometimes they have to hire a lawyer just to get the spouse to fill out, passport paperwork. Okay, and so you need the final order written in a way that requires, the primary parent to completely cooperate with things like passport paperwork, to take the kids to the airport, to fly them out there, to take all those steps so that if they don't, there are clear consequences for them. And so basically you have a guaranteed minimum amount of time with your kids. Okay, and so that's why, again, hiring a lawyer who handles these issues frequently, who can think about problems that might pop up in the future, okay, and address them now is very important, because it'll help you to prevent an inconvenience or an unfair loss of contact with your kid, because it's not good for you or your kids, okay? And also, again, hopefully prevent you from having to pay a lawyer again just so that you can see your kids, okay? So those issues are two of the main issues that we run into in military divorce cases. Other than that, some folks ask, well, I'm just rotating through, I don't own a home here, can I file in South Carolina for divorce? The answer to that question is yes, okay? As long as both you and your spouse have been here for 3 months, even if you don't intend to stay here forever, that's sufficient. There's a specific statutory provision that allows military folks to file here, even if they might own a home somewhere else. As long as they're living here, if they're both here for 3 months or one of y'all is here for 1 year, you can file for divorce in South Carolina. That's specifically addressed. And then the other issues that sometimes come up are about how BAH is calculated, or if someone is a reserve or guard, they may be called to active duty, and that may cause their income to temporarily go up. Okay, and if it's temporarily gone up, you want to make sure that their financial obligations aren't based on the assumption that it's always going to be at that increased rate. Okay, because if they go back down to inactive status, their income can drop, and if their financial obligations remain the same, that can put them in a real pinch. Okay, so again, that's the kind of thing that you need somebody who's familiar enough with how the problems that occur in service members' lives and the way that their payment works and things like that, who can really help you to resolve those issues, get a fair outcome, prevent conflict, hopefully, and if there is conflict, to present your case in a fair way and make sure that the judge has all the information they need to give you a fair and just ruling. So those are some of the issues that pop up in military divorces. Feel free to call my firm at 803-724-1258. We will give you a free phone consultation, and we do take cases in the Midlands and statewide. Thank you very much.